Maybe soon. Okay, are we ready to have the jury brought back?
Yes, Your Honor.
Can you switch back to the photograph just a second? Thank you.
You are in the meeting now.
Maybe see that. Sorry.
Chart changes. Okay, great.
All right, welcome back, ladies and gentlemen. We are ready to resume closing statements. Sherry, you can proceed.
Thank you, Your Honor. Good afternoon. This case is an incredible tragedy, and there's no doubt about that. There's no denying that. Ms. Warner's life was taken from her far too soon, and she was taken from everyone who cared and loved about her, family and friends. And they are grieving, and they are still grieving, as I believe you saw that from the witness stand. It never should have happened, but you're not here to determine if a tragedy occurred, because it did. And you're not here to determine if a killing occurred, because it did. What you are here to determine is if the government has proven its case against Mr. Warner beyond a reasonable doubt, and it didn't. I'd like to walk through some of the reasonable doubts this afternoon. And I want to begin with April 25th as we specifically look at Mr. Warner's actions. Then I'll explore the police investigation in general, the Warner's relationship, other people's actions on or and around April 25th, and then specifics about the police investigation. Now, it was Ms. Warner who told Mr. Wagner where to place the cameras on the Munger property, but they have turned out to be helpful because we can see Mr. Warner's actions throughout April 25th. This is detailed, but it is important. Exhibit 250 is the entire surveillance footage that you have, that you can look at any portion of it. And this is how Mr. Warner starts his day at 6:58. He's on the JCB. This is consistent with the health data that Detective Drew reviewed. In the middle of the night, there was no distance traveled, no flights climbed. Mr. Warner still had a heartbeat. but that would be the time that he would traditionally be sleeping. Now, this map shows where the JCB was at 6:58 on the Munger property. At 7:13, Mr. Warner is by the silo, and he shows up 3 times in the next 10 minutes. He shows up at 7:22. The JCB is heading north, and when you're looking at the surveillance footage, I think that you've probably realized you have to look essentially between the silo and the tree to see what's going on in back. He shows up at 7:23. The JCB at this point is heading south and west. And then this again is the area near the silo where Mr. Warner and the JCB are during those times between 7:13 and 7:23. At 7:30, we see Mr. Warner driving a forklift, and we're going to see this forklift in the same area that about 5 times. We see it at 7:33. We see it at 7:34. We see it at 7:40, 7:41 a.m. And then at 7:47, we see Mr. Warner leave the property on the sprayer to go to Leroy Sealers to spray. Now, please remember that the police did a reenactment to see if when Mr. Warner left the farm to go spray, both at Mr. Sealers and then the other 2 properties, if he actually could have done it in that time, and they learned that he could. They also looked at the GPS coordinates in the sprayer to see if it matched where Mr. Warner said he was going, and it did. So this is Mr. Warner on the property from 7 to 8 a.m. He's seen 10 times on camera as he does his morning farm chores. Now this is Ivan Boyd on the Munger property at 8:04 a.m. He's in the old shop. He's on the property for the majority of the day. At some point, his brother joins him, and he brings the truck that he's going to work on later at 10:39. And remember, there are no restrictions on where Mr. Boyd can go on the property. Mr. Warner doesn't preclude access to anyone. This is where Mr. Boyd starts his day and spends quite a bit of time in the old shop. Mr. Warner returns to the property at 8:12. And if you watch the surveillance video, you can see the sprayer come down Carson and take a left on Munger. That's the same direction that he left in. That's where Mr. Sealer's property is located. This is Mr. Warner and the sprayer at 8:18. And at 8:19, you can see the sprayer going right to the load barn in between the silo and the tree. As you know, the load barn is on the far east side of the property. It's what's been called frequently Building 7. At 8:46, Mr. Warner leaves again in the sprayer. Again, GPS coordinates match where he said he's going. We know between 9 a.m. and 10 a.m., Raquel Bach and Dustin Lally arrive on the property. They walk into the house because it's unlocked. Ms. Warner isn't there and they have breakfast. In the 10 to 11 a.m. hour, Ms. Bach and Mr. Lally go into the office. Ms. Bach walks into the unlocked office looking for Ms. Warner. And in the 11 to 12 p.m. hour, Mr. Boyd's brother arrives on the Munger property, as does Zach Bach as well. At 11:18, Mr. Warner arrives back in the property, and video will show that he walks from the load barn to the new shop. At 11:27, you see Zach Bach and Mr. Warner in the office talking and obviously looking for Ms. Warner on the cameras. At 11:35, Mr. Warner is walking away from the office near the silo and the scale. Meanwhile, in the office, Mr. Lally, Zach Bach, TJ Bach, Parker Hardy, Shelley Hardy, and Raquel Bach are already on the property. Mr. Warner is on camera walking near the pine tree at 11:36. He walks toward the new shop at 11:45 and leaves the new shop at 11:46. At 11:54, Mr. Warner is in the old shop talking with Mr. Boyd and Mr. Boyd's brother. So between 11 a.m. and 12 p.m., there are 7 people on the farm, in addition to Mr. Warner. Mr. Warner is walking all over the property, so the 7 people could choose to go wherever they wanted. At any time, anyone could walk into any building looking for Ms. Warner. And again, as you noted, with what Ms. Vinsky said in her opening statement and what witnesses have testified, there were no restrictions on where anyone went. At 12:13, Mr. Warner is in the office with Zach Bach, TJ, Mr. Lally, and Shelley Hardy. Mr. Warner is on the far right side of this image, up against the front desk. Mr. Boyd and his brother are still on the farm. At 12:19, we see Mr. Warner walking near the scales. At 12:21, he's heading back towards the office. At 12:23, Mr. Warner is driving the JCB. You can clearly and easily see into the bucket of the JCB. Here's the JCB again at 12:38, 12:39. And this is the location on the farm map of where the JCB is primarily located during that time period. At 12:43, Mr. Warner is in the old shop. On the right, you can see one of his dogs is running around. From 12:51 to 12:52, he's in the old shop. This is where Mr. Warner has a grinder and 2 grinder wheels. Now, this will become relevant when we talk about the welding expert who indicated that the number of wheels to cut that tank would take between 6 to 8. There's no indication that Mr. Warner ever took more than what he has in his hand right here. At 12:52, this is the Kubota that Mr. Warner would predominantly drive. We see it again at 1 o'clock. In between, at 1:13, in between 1:01 and 1:13, the videos of the Warag lobby show shadows. Now, if you watch that video, you can't see anyone come into the office, but it matches up with the Kubota heading towards the office and then later seen back by the fuel tanks. So one could presume that the driver of the Kubota went into the office, maybe had lunch, and then carried on their day. We see the Kubota again at 1:14. From 1:14 to 1:15, we see Mr. Warner in the old shop. At 1:16, the Kubota pulls in to another part of the old shop. Ivan Boyd and his brother are there. And please note, Mr. Warner knows that Ivan Boyd and his brother are in the old shop. He takes actually absolutely no actions to hide anything that he's doing. He also knows there are cameras, but he takes no action to hide what he's doing. We see the Kubota again at 1:23, at 1:26. Now, during this time frame, there are also multiple other workers on the farm that the police don't mention. You can see this gentleman at 1:36. He leaves the property at 1:44. You can see this gentleman at 1:42. He leaves the property at 3:15. During this time, Mr. Warner can be seen on video with the sprayer and walking on the property. This is the sprayer at 1:48. At 2:19, this is an image between 2 and 4. There are multiple people in the office. Again, very similar to earlier. Raquel Bach, TJ, Zach, Parker Hardy, and Shelley Hardy. At 2:19, Mr. Warner is in the lobby. At 2:27, he leaves the reception area. Roughly, it's almost 2:28 when he leaves. He comes back in at 2:31. He leaves the lobby at 2:35, so he's in there for a few minutes. And then he's on camera again at 2:38 in the lobby area. Now, you have heard witnesses criticize Mr. Warner for not doing enough. But then you also heard witnesses criticize him for looking over Zach Bach's shoulder to look at the cameras. So what you should glean from that is he really can't win. If he doesn't do enough, he's criticized. If he does too much, he's criticized. But just like every other person on video, he continues to go back to the lobby area to look at cameras and to talk about where Ms. Warner may be. At 2:42, we see Mr. Warner in the sprayer. He's in the Kubota at 2:46, 2:49. And the same piece of farm equipment that you saw in 2:49, we see in again at 2:50. Now, this is where it is on the farm. If you can see where the big silo is in the middle, that's where that piece of farm equipment was. We see him again at 2:51. He's back in the office at 2:55. Between 3 and 3:01, he's walking by the scales and you can see he has papers in his hands. At 3:08, he's in the new shop looking in a box and then walking away. At 3:12, he's seen leaving the new shop. Here's the piece of equipment at 3:13. This is Mr. Warner's truck at 3:15. We see the truck again by the fuel tanks. This is Mr. Warner's Kubota at 3:17, 3:18, 3:21. At 3:22, he's back in the office. He's there until about 3:36 p.m. At 3:37, we see the piece of farm equipment again. The Kubota again at 3:41. And if you can, please look at the field in the back because this will be important to what happens. The top part of that field is not tilled at 3:41. But at 4:06, you can see that there's movement in the field because it is being tilled. It only gets picked up because the white truck activates the motion camera. Otherwise, it never would have been picked up. Here's the video of that. If you look at that red box, you'll see there's movement in that field. It's going from this part of the screen to that part of the screen. So that shows the tilling that was done. Detective Singleton said there was this period of time where Mr. Warner was not on camera. He would be the only one to till that field. And at 4:12, you can see the part of the field that's being tilled, and you can look on here before the tilling and after the tilling. So the notion that he is not on camera is belied by the surveillance footage that the government introduced. And again, Detective Singleton said 3:41 to 4:29, Mr. Warner was not on camera. The only reason this got picked up was because of other trucks on the property, but he is working and not in the load barn. At 4:30, we see Mr. Warner's Kubota again. At 4:32, the JCB. At 4:37, it's the JCB again, where the inside of the bucket is clearly visible. 4:52 to 4:53, Mr. Warner is in the old shop. The door is clearly open because you can see the light shining in. This is where Detective Singleton said he was ducking down and trying to hide. You saw the video. If he was trying to hide, he would close the door. He wouldn't leave it open. At 4:56, he leaves the old shop. He's later seen in the old shop at 5:05 and 5:06 on camera. At 6:06, in between the silo and the tree, this is the movement that the government showed you with the JCB. That's it. This is Mr. Warner's Kubota at 6:06. 6:07, we see the JCB. 6:10 and 6:12, the JCB is going to the load barn and then leaving the area of the load barn. So going in there for about 2 minutes and leaving. 6:17, the JCB is headed back to the load barn. This entire early evening time at the load barn with Mr. Warner being in and out coincides with what Mr. Boyd said about helping Mr. Warner load trash. He talked about when chemicals are sent to the farm, they're packaged. They're packaged in sort of multiple layers. There'll be a white bottle, then it'll be inside something, then it'll be inside of a cardboard box. So there's no indication from Mr. Boyd that he saw a tank at the load barn or a welder or Mr. Warner with a tank or a welder in the load barn. At 6:37, the JCB is moving away from the load barn. Here it is again at 6:39. Then we've got the JCB going towards the load barn and away at 6:40 and 6:41. At 6:43, Mr. Warner is in the new shop. And this is a comparison of two photos, 3:12 and 6:43. So if Mr. Warner is trying to hide what he's doing and what he's taking, he's not going to leave it out on the table. So you can see where that piece of farm equipment is, and then it's not there at 6:43, but you can see that table. The first table, there's nothing on it. The second table are items that Mr. Warner had taken. And you also heard Mr. Nayrink tell you that Mr. Warner would do small welding jobs on the farm, especially if something was broken. So if there's a piece of equipment, a tilling tool, he said frequently broke down. It's a Sunday, there aren't many people there to do the welding. He wouldn't be surprised if Mr. Warner did it. And this is the end of the time period on April 25th, 2021, which is so significant. And the reason I went through all that time is because this is critical for what the government's claim is. The government wants you to believe that during this time frame, Mr. Warner killed his wife and then welded her in a body in a tank. Now, after 6:43, Mr. Warner is on the property doing more farm chores. He's collecting trash, using the Kubota, and tilling. And then again at 6:54, it's when Deputy Hall comes and talks to him. But that time frame is absolutely critical for everything that Mr. Warner would have to do to go along with the government's theory. Now, I want to walk through some of the specific reasonable doubts with you. Mr. Warner is captured on video throughout the day, morning, afternoon, and evening. As Ms. Vinsky told you in opening, the government's own timeline will fall apart upon close examination. So by 6:40 p.m., the government's speculative theory is that Mr. Warner killed Ms. Warner in the house while not leaving a single trace of physical evidence. Not a drop of blood, no bodily fluids, no signs of a struggle, absolutely nothing. And then at some point, he supposedly grabs a tarp and duct tape, but there's no camera footage of that. We know that the blue tarps are kept in the dry fertilizer barn, and the duct tape is in the load barn. But there's no evidence that he gathered these items, then went back in the house, presumably, and wrapped Ms. Warner in those. The government hasn't even addressed how Mr. Warner would get those items on April 25th. And then again, at some point, he supposedly duct tapes her body, wraps her body in a tarp, duct tapes the tarp. But again, there's no evidence of when that supposedly occurred. Then Mr. Warner supposedly moves the body, but there's no physical evidence of that. Nothing to show that she was ever in the JCB at all, only speculation. There's nothing on camera and there's no physical evidence. And while Detective Dreyer said, well, it was too late for them to look, they didn't even try to look. They want you to then assume that Mr. Warner keeps Ms. Warner's body in a safe, despite rigor mortis, as we heard from Dr. Cho. There are no physical signs of this at all. There are no physical signs with her body that she was kept in the safe. There's no physical or forensic evidence to support this theory whatsoever. Then Mr. Warner moves a tank without being caught on camera into the load barn, but again, there's no evidence of that happening. We see on the surveillance video that he doesn't take the grinder and the two wheels until 12:51 to 12:52, so all the rest supposedly happens after that time. In the load barn, without anybody noticing or hearing, he maneuvers the chain and the hook, welds that hook supposedly to the end cap of the tank, runs the chain through, connects it to the hook, tilts the tank so the chemicals don't run out. There's no evidence about how long it would take for that hook to be welded to the end cap so that it was structurally sound. It's not just a matter of welding it, it needs to be able to support the weight of that end cap. Mr. Boyd said those tanks were 6,000 pounds empty. Then Mr. Warner supposedly cuts open the tank. Assuming that she's in the safe, he has to go move her from the safe to the tank, lift her to get her up, then position together the end cap and the rest of the tank and weld it together. After that, he's got to remove the hook, remove the chain, sand the tank down so he can paint it. He then supposedly paints the tank, and while Mr. Schmidt said, well, that would dry quickly. You can look at the Rust-Oleum can. It's not immediate. And even if it was dry to the touch, we all have painted something. It's still going to be tacky. Things would still stick to it, but there's not one drop of paint in the load barn, not one drop of paint that was found on the chain or the hook, not a paintbrush, not the farm equipment, no debris on the tank. So if it gets moved out to the back, no dirt, no grass, the wind is blowing things, nothing is on it. There's no evidence whatsoever to support the theory. So while the government has shown you videos of Mr. Warner doing his chores and moving about the farm, they have shown you no evidence to support their theory of what actually happened. Assumptions are not evidence. Now, as you know, as it relates to searches, there were extensive searches for Ms. Warner in her property. Over 3,000 acres were searched, and that's one search alone. Searches occurred for years. Land, water, homes, buildings, vehicle. They were thorough. They searched in multiple towns and cities. Mr. Warner continuously consented to these searches over the years. The police searched every piece of land that Mr. Warner owned, leased, rented, or was even associated with. They searched land and homes that belonged to family members and people he knew. They didn't find Ms. Warner or any of her missing items. The police also searched Paragon South. They searched both north and south. South is where the tanks are. Nothing out of the ordinary was seen. There were multiple searches involving dogs, both cadaver dogs and tracking dogs, at least 7. There was lots of discussion about cadaver and tracking dogs, but you know from your common sense, a tracking dog is meant to track. So once it gets a scent from an article of clothing or whatever it might be, it is meant to follow that scent. The person doesn't need to be right there. Otherwise, it wouldn't be a tracking dog. Ms. Warner and her belongings were not located by those dogs. We know that cadaver dogs can locate blood, bones, or tissue for years. They can also identify a tiny drop of blood, including as small as what comes out of an eyedropper. They can smell through cleaning agents, and they hit on nothing. Nothing on any of the vehicles, nothing in the house, nothing on the property, absolutely nothing. During the searches, Trooper Tafe entered the load barn or was looking right into it. He couldn't quite remember on April 27th, but he never mentioned the smell of ammonia or chemicals. One point about these searches is Dr. Cho and Detective Druyer said there was a strong chemical smell from the tank when the tank was opened. Dr. Cho said it was an overpowering ammonia odor that was not part of natural decomposition. Numerous witnesses also said that anhydrous ammonia had a very strong smell, but you had a trooper right out of the load barn or possibly in who noticed no smell. Yet supposedly 2 days before Mr. Warner is cutting open this tank in that very enclosed area, there would be a smell if that tank had been cut open in an enclosed space. Mr. Boyd was in the load barn 2 to 3 times a week. He never mentioned a smell, not on April 25th and not after. Todd Nayrink met Mr. Warner at the load barn on April 25th. He didn't notice a smell. No one ever smelled anything out of the ordinary. Now, there was made, I think in the closing, they showed a snip of Mr. Warner talking about dogs in the load barn. The part that is omitted from that clip, but is in the video that you have as an exhibit, Exhibit 216, is Mr. Warner saying, the other thing I don't know about in the fertilizer barn, you got boots or something to put on them. He's not telling them that they can't go in. He's pointing out there are chemicals on the floor. So if the dogs go in, he didn't want it to get through their paws. If he's trying to prevent them from going into the load barn, he's not going to give them a solution as to how they can actually take the dogs in by putting boots on their feet. Numerous items of Ms. Warner's were missing and are still missing. Her phone, wallet, passport, driver's license, a purse, and go bag with items such as cosmetics and hair care items. These items, as you know, were never found despite numerous searches with ground penetrating radar and metal detectors, things that would look for changes in temperature or excavation. In one multi-day, large-scale search alone, there were 130 police officers. There is not even a theory that has been presented to you about where these items are. Now, Mr. Warner also had said a curling iron was missing, but then the police found it had fallen on the floor in between a cabinet. If Mr. Warner had been the one to take these items, he would know that a curling iron wasn't taken. He wouldn't say a curling iron was missing when it's actually still in the house. He was trying to guess based on what wasn't on the bathroom shelf. This is further evidence that he didn't take and conceal these items. Mr. Warner spoke to the police numerous times, frequently without a lawyer present. The only time we saw a lawyer was the December 2022 interview with Detectives Druyer and Singleton, where his lawyer was there. He had the legal right to refuse, but he didn't. He frequently spoke to them, again, without a lawyer present. And if you listen to those videos, you do hear him coughing. And what did we hear from his ex-wife? He's had that cough since they were married. It annoyed her then, it's continued on. That's not from recent exposure to anhydrous ammonia. Despite what he says now, Detective Druyer had to admit that previously he indicated that Mr. Warner's statements were fairly consistent about what occurred. And of course, details would change. You're being asked the same questions over and over again. We know that their daughter, Angelina, had spent Friday night at her older sister's, Ms. Million, and then Saturday night with Ms. Alexander. So it would be very easy to confuse those nights about what happened on one night or what happened on another. We've also seen multiple witnesses, including law enforcement, have to get their memory refreshed because they couldn't remember something. And we have even heard other witnesses say they didn't say something when they truly did. That happened with Ms. Warner's brother. He said adamantly he did not make a statement or he did not send a text message when he actually did and had to be shown that. So the fact that some details may change does not mean that Mr. Warner was not being truthful. But Mr. Warner was always adamant that he did not harm his wife in every interview. And he also offered ideas and suggestions about how to find Ms. Warner. In the May 3rd, 2021 interview alone, which is Exhibit 219, Mr. Warner speaks with Detective Greca about a phone number and license plate that could be relevant to where Ms. Warner was. He asked if he should call the insurance company to see if Ms. Warner checked herself in somewhere. He suggests that they come up with a list of names and go through Facebook to see if she's made contact with any of these people. He gives the detective names of Ms. Warner's friends and who to reach out to. And he asked Ms. Warner's best friend, Stephanie Vogel, if she knew of anyone who may have picked Ms. Warner up. And he does more, but he's not showboating. He's not trying to make a splash in the public. The government wants to present Mr. Warner as someone who did nothing, but that's not true. He tried to offer assistance in the background, and he tried to keep his daughter's life as stable as possible because her mother was missing. Now, in his private journal, which the police found in October of 2021, he goes further and he writes down ideas of where Ms. Warner may be, what aliases she might be using, ideas to try to find her. These are the private actions of a man who wants his wife to come home. He's not going to be journaling that if he knows where she is. And during that May interview, Detective Greca also talks about the importance of Mr. Warner taking his daughter to a soccer game in order to give her support and keep her life as stable as he could. That goes along with why he might not be participating in a search because he's got a 9-year-old he's trying to take care of. In the interviews that you listen to, Mr. Warner also turned down theories offered by the police that he would have seized on if he was trying to misdirect them. For instance, Detective Greca talks about gambling. Mr. Warner said that's not Ms. Warner. He talks about suicide. Mr. Warner says, while she may have made some comments about that, he didn't think that was a real possibility. If he's trying to misdirect the police, he's going to send them down all different kinds of paths. And these are theories being offered by the police. And we heard a lot about Jamaica and Mexico. Mr. Warner is prompted by investigators to discuss Jamaica and Mexico numerous times, instead of Mr. Warner consistently bringing it up on his own. Now, in the December 2022 interview, at this point, his wife has been gone for over a year and a half. So it's probably pretty clear she's not just in the next town over, and it's very clear she's not at her son's. So of course he's trying to come up with any possibility of where she may be. And in that full interview, he doesn't say, "Oh, I think she's in the hills of Jamaica living with the cartel." He talks about why. She liked Jamaica. She made friends with the concierge. She liked the mansion. She thought it was beautiful there. Even Detective Drewer on the stand said that Mr. Warner seemed convinced that Ms. Warner was in Jamaica. Mr. Warner also told Detective Greca that if Ms. Warner left or was picked up by someone, there was not that big of a window for Ms. Warner to get out of the house. If he had harmed her, he wouldn't want to shorten this time frame. He would lengthen it. He would say, "I heard the door close at 1 a.m." or I looked out the window and she was walking out at 2 a.m. He would lengthen the time that she was gone, not shorten it and say to the police, it's not a very long period of time for her to get out of the house. While he believed that Ms. Warner had left as she had done before, he also said that there were differences this time, and he was candid about that. The vehicles were there. She didn't take their daughter Angelina. She didn't notify anybody, and the ring was on his desk. He didn't have to say that, but he was frank about the differences. He also repeatedly said to both the police and others he wanted his wife back. Detective Greca said that Mr. Warner showed emotion during the interviews when talking about his wife. Throughout all the interviews, I don't know if you picked up on this, but Mr. Warner always refers to his wife in the present tense. She is a fixer. He doesn't say she was a fixer, which he would say if he knew she wasn't alive. He refers to her in the present tense. And Mr. Warner saying he doesn't want to get divorced doesn't mean he killed his wife. It means he loved his wife. They had been seeing a counselor, Craig, as you saw from the text message exchange and Detective Drewer said, which shows his willingness to work on issues with the marriage. And he was frank about the fact that they fought. Tensions could run high. He told the police that. He also wrote about this in his private journal. If the inference is, oh, well, this is staged, what he's writing about, why wouldn't he turn it over to the police? Why wouldn't he said, "Hey, I've been keeping a journal"? The police find it in a vehicle in October of 2021. And in that, he talks about comments that Ms. Warner made and troubles that they have in their marriage, that Ms. Warner says that he's mean to her, that essentially he doesn't appreciate her. He wouldn't write that if he wanted the police to find it and think everything was fine in their marriage. He would try to present their marriage as being more peaceful. Now, we know that Ms. Warner had talked about ending her marriage for years. This was nothing new. We heard this from numerous people. In Exhibit 194, we see Ms. Warner telling Mr. Warner that unless he shows her more that he cares, she'll end the marriage the same way she did with her first husband. But we also know that her plans would change day to day according to her moods. Numerous people, including her brother, very emotionally talked about the fact that she'd love you one minute, dislike you the next, and then the next day give him a hug. Exhibit 198, you can see on March 4th that Ms. Warner is saying, "fuck you," and that she's not going on vacation. And then the next day, March 5th, they're talking about regular things just like any other married couple. The text message exchanges show Ms. Warner and Mr. Warner having arguments between spouses, which happens in many marriages, unfortunately. But it also shows her expressing herself freely to Mr. Warner, which we heard she did to him and others. She would express her feelings. She wouldn't hold back, even if that meant raising her voice to Mr. Warner and to others. Numerous people testified that Mr. Warner is not an emotional person. He's laid back and easygoing. Ms. Million said that Mr. Warner's response to Ms. Warner when she said she wanted to sell everything and be done on April 25th was, "Okay, whatever, Dee," because he had heard similar comments before. Despite the fact that Ms. Warner would regularly say she wanted to end her marriage, she asked Ms. Bokel to book vacations for her and Mr. Warner, 2 in 2021 and 4 in 2022. Her plan was to go on vacation with her husband and daughter, But one of the vacations was just for her and Mr. Warner alone, to just have a couples trip. This shows again that her mood would change. She would be angry at him, but she would also want to spend alone time with him. Mr. Warner would regularly rub Ms. Warner's shoulders or back at work. He often did so in the office. Despite how Ms. Vocal attempted to portray their relationship, she had already told the police that and had to admit that on the stand. Now, we know that the Warners had a mutual mistrust of each other. That's clear from what was presented at trial. Ms. Wolf said that Ms. Warner would drive to the farm fields to see if Mr. Warner was where he said he would be. She said that the two of them would snoop on each other, including Ms. Warner taking a phone that belonged to Mr. Warner and giving that to Ms. Wolf to hide. Mr. Lally said that Ms. Warner would speak in quiet and hushed tones to himself and to her daughter when Mr. Warner was in the house to intentionally exclude him from conversations. There was a safe where she and her son were hiding things from Mr. Warner. Ms. Wolf also admitted that Ms. Warner was having an affair. So Mr. Warner, wondering if that had been going on, actually had a basis in fact. He wasn't just imagining it. Ms. Wolf, who was also Ms. Warner's personal assistant and nanny, said she would see Ms. Warner drink alcohol every day. And this supports Mr. Warner's concern about substance use. This is Exhibit 210. That cabinet are the pills that she had in her home. And look at the details, please, of what the government characterizes as stalking behavior. The cameras that Mr. Warner spoke to Mr. Bush about were about 4x6, and they had an antenna on the top. Those aren't cameras that are going to be hidden from any person. The OnStar application shows an average of 4.2 vehicle location requests a day. But Mr. Newell said that the app doesn't show a vehicle moving. So if you're trying to track and see when someone is coming home, because you want to know when they're going to be there, you want to have dinner with them, whatever the situation is, you're going to keep refreshing the app. The get vehicle location can also be used as a navigation tool as well. So if they were driving together and he wanted to see where they were going or how to get someplace, he would use the app. Ms. Vocal also said that she saw the entry on Mr. Warner's credit card for the Binks device, the device that had been in the Hummer, and that she and Ms. Warner looked it up to see what it was. That's the GPS and diagnostic device that was found. But we heard from Mr. Bush that he paid for the device and the government showed you an Amazon image. This discrepancy goes to witness credibility and the witness's desire to present the case in a particular way. And it makes sense because they all loved Miss Warner. There's no doubt about that. And of course, they want to present her in the most favorable light and Mr. Warner in the least favorable light. But the facts matter, not assumptions. And the other thing presented by the government is, well, when Mr. Warner wrote in his journal that Ms. Warner left in the middle of the night, he didn't check OnStar. But if she didn't take the Cadillac, he'd have no reason to check OnStar. If Mr. Warner was truly stalking his wife, he would have insisted on access to the surveillance cameras long before she went missing. He couldn't even view the cameras on his phone until after she went missing. Mr. Wagner told you that it had been about a month or two where the IP address had changed on the Munger property and that Mr. Warner had no access to those cameras. So while he might have tried to access the app on the morning of April 25th, he couldn't access the app to see those cameras. We also know about the phone that Ms. Warner was in the hospital. That's what Mr. Wagner said. He was also Ms. Warner's friend. Mr. Warner wanted the phone for business purposes. He didn't ask him to keep it a secret from Ms. Warner or try to keep it private. In terms of accessibility and transparency, Mr. Warner also allowed Detective Greca to talk to his minor daughter even when he was not present. And if he was trying to hide the true nature of their relationship, he never would have allowed that. Angelina wasn't there the night of April 25th, but she lived in that house with them. A 9-year-old is going to know what that relationship is like. She would have heard verbal disagreements. She would have known if there was any other sort of physical disagreement. She would be able to share that with the police. He put no barriers to their access with her at all. Now, as it relates to any sort of physical violence, Ms. Wolf never told Detective Greca about seeing a bruise on Ms. Warner's forehead. If she'd truly witnessed this, it would have been the first thing she told the police when she spoke to them. Ms. Brody also didn't document any of the supposed bruises she claimed she saw as a massage therapist. She had twice testified under oath, and at neither of those court appearances did she ever say anything about a handprint on an arm. And it's worth repeating here that you are not here to judge Mr. Warner as a husband. You may think he was a bad husband, a not very attentive husband, whatever you may think of him. Your oath requires that you only assess the government's case to determine if it has proven beyond a reasonable doubt that Mr. Warner killed his wife and tampered with evidence. Now, we've gone through April 25th and an overview of the Warners' relationship, but I want to also move on to what else is going on between April 23rd and immediately after April 25th and the police investigation as well. On Wednesday, which would be April 21st, Ms. Brody, Ms. Warner's friend and massage therapist, said she saw Ms. Warner and Ms. Warner was distraught and shaking. We know Ms. Warner was a person who had strong emotions and she felt them, but there's absolutely no justification for what's happening here. According to Ms. Brody, Ms. Warner said she wanted to see a lawyer and it was time. But we know the fight with the Terrys, Terry and Terry Nayrink, wasn't until Friday. So there's no indication of what was going on Wednesday, and there's never been an exclamation or an explanation for this. Again, on that Friday, April 23rd, Ms. Warner had a verbal disagreement with Todd Nayrink, who testified. You also heard that Ms. Vocal heard them yelling at each other, but then she also said Ms. Warner seemed happy when she left work that day. So in addition to the fights with Todd, she had the fight with Terry and Terry. Mr. Nayrink, Todd Nayrink, said that on Friday, Ms. Warner was not dressed as she normally would. She was in sweatpants. Mr. Hawkins, who worked on the farm for the Warners, spoke with Ms. Warner at about 6:30 p.m. on Friday, and he said she sounded normal. Ms. Alexander saw Ms. Warner at 7:42 p.m. when she went to pick up Angelina. She said that Ms. Warner kept putting her hands up to her head, and she was talking about a fight she had with Terry and Terry Nayrink. Earlier, Ms. Warner had said that she had a migraine, so that would be consistent with her having a migraine, and we know she was being treated for migraines. Later that night, Raquel Bach claims that she drove by at 10:30 p.m. and saw all the lights on. But closer to 11 o'clock, Dustin Lally drives by. He said Ms. Bach had left well before him. And on cross-examination, the only light that he had said was on was one light. He didn't remember anything unusual about the house, which matches with what Todd Nayrink said when he arrived on the property in the 3 a.m. hour. There was only the light on over the kitchen above the sink. Now, on April 25th, 2021, the OnStar report shows that Mr. Warner's phone app accesses My Cadillac to get vehicle data and then supposedly hits unlock the doors at 7:08 a.m. Get vehicle data is to check on things like oil, tire pressure, fluids in the car. The government's theory is that Mr. Warner had killed his wife by this time, but then he decides to check on how the fluids are in the car or the tire pressure. It makes no sense. And this is part of what Ms. Vinsky also said to you in opening statement. The government dismisses and ignores facts that conflict with the narrative that they are trying to present. Mr. Warner uses Find My iPhone at 8:48, 10:28, and 2:30, and he would not need to do this if he knew where the phone was. And if the government's theory is that, oh, he was trying to see if you could find it, well, he would have checked it at 8:48, can't find it, checked it again at 10:28. He wouldn't need to keep doing that. He would know at 8:48 the phone can't be found. He did it because he was trying to see where Ms. Warner was. And while at 8:48 he would not have known that Ms. Warner was missing, it's not unusual for a spouse to check Find My iPhone to see if your spouse is up, or are they at the office, or are they at the grocery store. And while the Milestone app, again, was accessed at 8:49 and 9:04, we know from Mr. Wagner, Mr. Warner couldn't see anything on the cameras. Now, Mr. Lally said that when they went over to the Munger property It was the same as what they had done pretty much on every Sunday. They would go over and have breakfast. Mr. Warner knew this, but he took no actions to restrict their movements that day. In fact, he wasn't even on the property. If he had killed his wife, is he really going to leave the property and let people roam around wherever they want? He goes out spraying. Numerous witnesses, including Mr. Lally, Zach Bach, and Raquel Bach, said that the Warners never locked their house. It was always unlocked. Anyone could walk right in. And that's what they did on April 25th, 2021. That day, when people were looking for Ms. Warner, they looked at places that she could walk to, even though people said she didn't like to walk. They went to the Hardee's Event Center and home. They went to the Cedar Point property. Mr. Lally looked in the camper. But we know from Ms. Wolf that Ms. Warner would walk to the office, contrary to what other witnesses said, and that she was starting to walk everywhere because she was getting into fitness. Also, witnesses support that Mr. Warner was in fact spraying. Not only the GPS data and the reenactment, but Parker Hardy said that when he was at the house with his mother, Mr. Warner drove by on the sprayer. Now, Ms. Warner's phone last connected to a cell tower at 7:14, and the last internet connection was 7:01. So as we turn to the police's review of activities, which is essentially the last section of my closing, I want to talk about this a bit. This is part of the PowerPoint that was presented to you. Ms. Ziegler said that Ms. Warner's phone connected to two towers that morning, 226601 and 226609. This is an example of that portion of what she said during her testimony. And Ms. Ziegler said these were the two towers, north and south. And I specifically asked her that question. Are you saying the towers are north and south? Yes, they are, she said. And this was the slide that she used to conduct her analysis. You'll have this as an exhibit, so it might be hard for you to see, but the north tower is not 22601. It is 226543. 22601 is to the east in Tecumseh. So the analysis about the phone's location is flawed because the two towers that should have been used would have been the south tower and the east tower. But Ms. Ziegler used the south tower and the north tower. But one thing about her testimony that is correct is that she can't distinguish any movement from the phone, because we know that a phone will connect to a cell tower even if it's not the closest tower for numerous reasons that have nothing to do with movement. Now, moving to April 27th and the tank, if Mr. Warner wanted to secretly move a tank on April 27th, he would have done it when the police left for the day. Remember, they were there in the morning. And then he walked around with Detective Greca for a period of time. And then he said, I have to go to work. If it rains, you can come back or come back tomorrow. And then they got a search warrant and they showed up later on that day. He knew that they were there with drones and a dog. If he had a concern about that, he wouldn't have just gone to farm. He would have moved the tank that everyone is saying he's trying to hide. He would have done it when the police weren't around. He also could have or would have moved it on April 26th, and again, not waited for the police to come back to his property. There's also, again, no issue with the fact that he asked the police to leave earlier. That is his legal right. And he explained that to the police. Now, just as earlier mentioned, where people didn't notice any smell of ammonia in the load barn, Detective Sharp, who was in the load barn or in front of it for an extended period of time, also did not indicate that he saw any or smelled any sort of chemical smell. Mr. Gravel moved a tank into the spray barn. This was the rusty tank that we saw being moved. He didn't notice any sort of strong chemical smell, which he would have if that tank had been cut open in the load barn. Mr. Hawkins is also regularly in the load barn. He would be in the building 1 to 2 times a week, taking in the JCB and removing empty bottles. And again, at no point in time does he ever smell ammonia or indicate that a tank had been cut open. There was also nothing unusual about moving a tank. Mr. Gravel told you that he had moved tanks before. Mr. Hawkins said that tanks would be brought back and forth from the Carson Road property and the Paragon property. We also know from Mr. Hawkins that business was slow in 2020 and 2021 for anhydrous ammonia. They didn't need extra tanks. They had plenty of tanks. So moving a tank or not fixing a tank wasn't a big deal because they had so many other things to do and they had so many extra tanks. We also know that week of April after Ms. Warner goes missing that Parker Hardy says he didn't see anything unusual about Mr. Warner painting in a hydrous tank. And he didn't notice a non-factory weld on the tank he saw in the load barn. Parker Hardy had been in the load barn numerous times. This wasn't a place that people don't go. And remember, the Hardys had even more access to the property because they were family. So while maybe some person who used their services might not freely walk into the load barn, the Hardys would. And again, Mr. Warner took no stops to keep anybody out of any building, making the story that he was welding her in the load barn not plausible. Now, the only person who claims that there were JCB tracks that went right up to the house was Parker Hardy. He said he thought the JCB was moving quickly because of the way the gravel was aside, but he also said he didn't see any reverse tracks for the JCB, which would be unusual. But the supposed fast-moving JCB is inconsistent with the reenactment where the gentleman driving the JCB was afraid to go any further because he thought he would potentially hit or damage the house. And the other thing too about this moving of the Hummer, if Mr. Warner wants to move the Hummer in order to park the JCB there, he doesn't have to put it in front of the office. Literally, all he has to do is back it up and move it one spot over. There'd be no reason for him to move it in front of the office. Now, jury instructions that you'll be receiving soon from Judge Olsaber indicate that you have to decide which witnesses you believe and how important you think their testimony is. You can have tremendous empathy for a witness, but not believe everything that the person says. You can also consider how some witnesses answered questions and if there was a difference in how they answered questions when the government asked them questions and how they answered questions when the defense asked them. You can consider a witness's feelings and a desire to portray events in a particular way. So for instance, Ms. Stace, the eyelash professional, when she testified, she said that Ms. Warner received 2 phone calls, one of them from Mr. Warner, and she didn't take that call. That would lead you to believe, if you were listening to that, that she did take the other call, but she was just intentionally not taking his call. But the reality is, when asked on cross, she said, oh no, Ms. Warner didn't take either call for whatever reason. She's getting her eyelashes done or she just doesn't want to talk to anybody. And even consider Detective Sharp when he testified. He said he knew Ms. Warner from prior police contact, which again would lead you to believe, boy, maybe he went out there because of a physical disagreement with Mr. Warner. It was only on cross-examination that Detective Sharp indicated that it had nothing to do with Mr. Warner. They weren't even together. It was solely related to Ms. Warner. Now, as it relates to Dr. Cho, please remember that he said he could not tell by the condition of Ms. Warner's body what the date of death was. He couldn't tell the date, the month, or the year. One of the things that the government has to prove is that these crimes were committed on or about April 25th, 2021. There's a little leeway there, but Dr. Cho can't even tell you the year based on the body's condition. The only way that he gets to April 25th, 2021 is because that's when people tell him was the last time that Ms. Warner was seen. But that's not objective evidence of the date of death. So considering objective scientific evidence only, Ms. Warner's date of death is actually unknown because Dr. Cho could not determine it. Dr. Cho doesn't know the time of Ms. Warner's death. Dr. Cho does not know the place of Ms. Warner's death. Dr. Cho does not know if Ms. Warner was killed inside or outside. Dr. Cho also does not know what caused the blunt force injuries. With strangulation, there can be a loss of bodily fluids, whether from the bladder or bowels. There was, again, no evidence of this found in the Warner home or on the Munger property or any property associated with Mr. Warner at all. With Ms. Warner's injuries, there could be external bleeding. There was no blood evidence found at all in the Warner home, on the Munger property, or on any property associated with Mr. Warner. And while the government wants to present her as wearing pajamas, remember Dr. Cho said it could be pajamas or a sweatsuit, and that she was also wearing underwear and earrings. Now, as it relates to body position, rigor mortis is the stiffening of muscles after death. Dr. Cho said rigor mortis sets in generally after a few hours and it will last about 24 hours. If rigor mortis lapses, the body will remain in the same position that it would be in. Now, there again is no physical indication that Ms. Warner's body was manipulated in any way to get her in the safe. There's no indication she was folded up as Detective Drewer was when he did his reenactment. There's no physical evidence of that. It's a theory, but it's not backed up by any evidence. And the government has never said when this supposedly occurred on April 25th. And also note, Mr. Warner willingly opens the safe for the police. They say, listen, we have a warrant. You can either open these up or we're going to cut them open. And he's like, oh, that's all right. I'll open it up for you. Would he really do that if his wife had just been in the safe? Now, on the Welding theory, Detective Drewer and his former partner, Detective Singleton, claim that they had a welding theory as early as April 22, yet they never shared this with Lenawee County Sheriff's Detective Kevin Greca. And respectfully, this makes no sense whatsoever. They are literally looking for a missing woman. She has children and a family who want her to come home. They've got this theory, but well, they don't want to step on any toes. It would be awkward. It would be impolite. You would present the theory. If Detective Greca didn't act on it, okay, that would be on him. But they wouldn't shut themselves down from even mentioning it if it truly had happened in April of 2022. And Detective Drewer saying, well, we were concerned about a leak. That leak supposedly occurred in March of 2022 at that family meeting, which we'll get to in a minute. But the leak wasn't with the Lenawee County Sheriff's Department. The leak was with a federal law enforcement officer, a U.S. Marshal. So again, maybe you don't want to tell that Marshal, but you certainly would tell a Lenawee County investigator about your theory. They are actively working to find her. They are following up on psychic tips. Yet they're not willing to share, hey, we think she might be welded in a tank. As it relates to the tank, Mr. Schmidt examined that tank multiple times. It was only in his final meeting with the detective and an assistant prosecuting attorney that he suddenly thought that the weld on take 34 may be similar to the weld seen on Detective Greca's body camera. The meeting was on February 9th, 2026. Trial had started. And then only then did Mr. Schmidt change his opinion. At a meeting on September 24th, 2024, he was shown an enhanced image from April 27th, 2021. And he could not make a comparison about the weld in the photograph and the weld that he had viewed personally. Mr. Schmidt also admitted that cutting the tank would be faster with the plasma cutter, which was right next to the welder on the Munger property. And the purpose of a plasma cutter is to cut through metal. Again, Mr. Warner is shown with 2 grinder wheels, but Mr. Schmidt said it would take 6 to 8 wheels to cut the tank open. Mr. Schmidt also said that cutting with an abrasive wheel would be loud. You would have to wear protective hearing. Anyone could have easily heard Mr. Warner if he was cutting and then welding that tank. But nobody did, even though there were people on the farm. Now, no one can match the hook or the chain that was supposedly attached to the tank and used to lift it up. It's just speculation that this even happened. It's the same with the forklift claim. There's no evidence that it actually happened. And this, again, Mr. Schmidt only came up with in January 2026, when trial was starting at the end of the month. Suddenly, he's got a theory about a hook and a chain. It's the same with the welding machine. Mr. Schmidt can't say that that welding machine was used to make that weld, and he can't match a weld to a particular person. He also can't say how many machines exist that you could do that with, that would fit the parameters. Mr. Schmidt also didn't use a student to come up with his time estimates. And that's what he should have done. He has over 20 years of experience as a welder. He is an instructor on welding. Of course, he would be able to go significantly faster than a regular person. But even with what he said, the welding timeline doesn't fit with Mr. Warner's actions on April 25th. The tank circumference is 128 inches, and that steel is thick. Even if we use Mr. Schmidt's calculations, he said to cut the cap off, it would be about 2.5 inches per minute. This is for him 51.2 minutes with the grinder. And then high spots would need to be ground down. That's about 5 minutes. The hook would need to be welded on. Again, no time was given for how long it would take for that to be structurally sound to support that end cap of that 6,000-pound tank. Then the chain would need to be looped through the forklift. The two pieces need to be lined up and matched once it's time to weld. The weld itself time, 22 to 35.5 minutes with additional time for 11 stops and starts and moving up and down a ladder on the floor to get underneath the tank. Mr. Warner isn't in the load barn for that length of time to get all of this done. Maybe Mr. Schmidt can do it, but he couldn't. And then painting. And then the government wants you to believe that after killing his wife and concealing her body and doing all this, he's just out and about doing his farm chores as if nothing is going on and then just taking a break to go and conceal evidence. We also know that chemicals on the farm also cause burns on the skin. Mr. Hawkins told you that, as well as Mr. Boyd, who actually has had that happen. He said chemical burns can cause your arm to be red and very itchy. If Mr. Warner was welding, he could have easily, and wanted to hide it, he could have easily put on a long sleeve short shirt. And if he's trying to hide welding burns because he just welded his wife up in a tank, he would have put on a long sleeve shirt so no one would have ever seen that. He doesn't do that because he's not hiding anything. For the paint analysis, all that can be said is that the paint may have come from paint that was taken in 2024. 3 years later, over. Or it may not have come from paint that was taken in 2024, over 3 years later. It was also a level 3 association, and there are 5 different levels. In part, a level 3 association states because other items have been manufactured that would also be indistinguishable from the submitted evidence, an individual source cannot be determined. Ms. Pontke told us that paint is mass produced and an individual source in this case cannot be identified. She can't even tell us the manufacturer of the paint. There is no way of knowing how many similar paint cans would be similar to that used on tank 34. And she said that the paint here, Rust-Oleum, is a common paint. There's also, again, no evidence about when the paint was purchased. And that's the same for the duct tape and the tarp. Detective Dreer said it's not surprising that these items would be found on a farm. It's also the same for the stickers. No one knows when those stickers were purchased. And we know that the drawers and the building doors on the farm were unlocked. The two tank samples were similar to 2 different paint cans. Think about that logically. Someone is painting from one can, and then for a reason that no one knows about, they decide to stop with that can, it's not empty, and use another can of paint to finish. The fact that it relates and is consistent with 2 paint cans means it could be consistent with 1 million or more. We just don't know because there's no way to know. Now, while Ms. Pontke took the paint samples, she also said that the stickers on the tank were peeling back. The supposed middle fingerprint from the back of the label on the outside of the tank is from the non-repair weld. It's the other side, and that's relevant. There's no indication of when that sticker was put on. And another thing about the fingerprint is only 7 points were consistent out of 15. And there's no standard to indicate identification or not. It is the analyst's subjective determination. And the analyst did admit identification does not mean the exclusion of others. Now, as to the call you heard from Mr. Warner, at that point, there had been extensive searches on his property, and we heard from Detective Dreyer that that was damage done. There was damage to the Hummer, there was damage to underground lines, they had taken samples off of a couch. So, of course, someone would be annoyed or frustrated by property being searched yet again that had already been searched. But we also know from listening to that call, because we listened to the full call, that Mr. Warner wasn't in a panic, didn't hang up the phone. He continued to talk about a planter's wart, school supplies for his daughter, books, and food, not the action of someone who is like, oh no, they just found my wife. And just as he's not panicked when he agrees to the police routinely searching his electronic devices. So the government has made quite a bit about the searches that were made. Mr. Warner consented to a search of his electronic devices numerous times. We know that. He knew there were text messages between himself and Ms. Warner on the phone. He wasn't trying to hide those. They show that they fought. He also knew what his searches were, searches that occurred after Ms. Warner went missing. He had extra anhydrous ammonia tanks. We know that from Mr. Hawkins. So searching on how to dispose of a propane tank makes sense for the business that he's in. And this chemical cremation search, if he's trying to find some way to dispose of his wife's body, why would the search be chemical or liquid cremation and he's searching, is it illegal? He wouldn't care if it was illegal. He supposedly killed his wife. He wouldn't be worried about, okay, well, now I want to make sure I legally dispose of her body. He doesn't try to hide that. He lets the police search his devices numerous times. Now, a reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. And when you're considering all the evidence, you can consider the lack of evidence. And that's part of the reasonable doubt instruction. The police searched the Warner home and they used luminol. No blood is found. There's no evidence that Ms. Warner was murdered in the home at all. Again, no blood, no bodily fluids, no signs of a struggle. Police searched the home multiple times, no evidence of murder. They searched the Munger property multiple times, no evidence of murder. There's no evidence that Ms. Warner was in the safe, no blood, no hair, no DNA, absolutely nothing. And it's the same for the JCB. And Detective Drury can say, well, we can't find the safe any longer. It doesn't matter. There's no evidence that she was ever in the safe. The police took Ms. Warner's fingernail clippings, but no one bothered to check to see if there was DNA found under her fingernails. There's no physical evidence linking Mr. Warner to Ms. Warner's body or her death. And again, it's the same for the duct tape, the tarp, and the inside and outside of the tank. The outside of that tank was powdered for fingerprints. His fingerprints weren't on that. There also is no physical evidence linking Mr. Warner to this murder in any fashion. And when we talk about those tanks, also consider that tank at the Paragon property was found on running gear. But when you look at all the video footage from the search of the Munger property, there's no extra running gear that that tank would be placed on. The tank, the tag on the tank, the police take no steps to determine if it's Mr. Warner's handwriting. They want you to do a sort of line by line comparison yourself, but no expert has ever taken a look at it. You can also consider other things that the police didn't do. Now, the Hardy farm is right next to the Warner farm. They only searched that farm years later and only because of consent searches. Now, is anyone saying that Greg Hardy or a member of the Hardy family harmed Ms. Warner? No, absolutely not. I want to be clear on that. But what we are saying is that Mr. Hardy did engage in some unusual conduct, as we heard from Detective Dreyer, which I will get into. They should have at least looked into that to rule someone out. And I say that because the only person they appear to have ruled out is Ms. Warner's affair partner. They should have followed every lead, but they started this investigation with blinders as it related to Mr. Warner. We know that Mr. Hardy claimed to the media that he told the police about a particular tank to look in to find his sister. Now, again, he didn't say tank 34, but he said, I want you to look for a particular tank. And Detective Dreyer said, no, that didn't happen. That was not true. So they should have at least looked into that further to say, like, why on earth is he saying that? He said he was getting insider information from a federal law enforcement officer. He and his private investigator, who he was working with, Billy Little, and a podcaster, call Detective Drewer and Detective Greca out of a family meeting. And what's the reason for that? They wanted the police to pretend that Mr. Hardy was giving them his phone for a download, but really he wasn't. So he wanted this like false narrative of that he was engaging in this. But Detective Greca and Detective Drewer refused to go along with that lie. He also revoked consent to listen to interviews that had been conducted. And he expressed concern about liability if there isn't a conviction against Mr. Warner. Now, again, they should follow every lead to rule people out. It doesn't mean that anybody was involved. So it doesn't mean that the affair partner was involved, Mr. Hardy was involved, another third party. Doesn't mean that Terry Nayrink, Todd Nayrink, none of that, right? But those are individuals who should have at least been looked at and looked at thoroughly, because when people are engaging in suspicious behavior, you should look into them to do a thorough investigation. Finally, this is the burden of proof chart that visualizes essentially how high that beyond a reasonable doubt burden is. It's not whether you think someone is probably guilty, likely guilty, there's clear and convincing evidence of guilt. That's not the standard. It is whether the government has proven the case beyond a reasonable doubt. And I've shown you multiple reasonable doubts this afternoon, and you likely have more that you will come up with as you deliberate. But the power of the government to prosecute someone should never be fueled by assumptions and speculation and innuendo. It should only be fueled by facts. Otherwise, devastating results can occur. Assumptions blind people to facts, and they blind investigators to follow leads that they may not think might bear fruit, but they certainly should look into. Despite the lack of objective, scientific, and forensic evidence, Mr. Warner sits here charged with multiple serious felonies. Now, I don't believe that Mr. Warner should be, we're presenting to you that Mr. Warner should be convicted of any felony. But if you consider premeditation, it does not exist here, because if he had premeditated this killing, he would have had the items that he needed already. He would have had the welding, he would have had the tank, he would have had the wheels. He wouldn't be gathering those on April 25th. So their theory is that he's gathering these after the murder, which guts the premeditation element. Because the government has not proven their case beyond a reasonable doubt, we ask that you follow your oath and find Mr. Warner not guilty on all counts. Thank you.
All of the surveillance footage. We're going to give you all of that so you can look at that. We presented a couple of clips of those. They've presented some photographs of times. With everything that's been presented, he still has enough time. The 126 to 146 that we discussed, that full 20 minutes, that he was in the spray barn during that time. 341 to 429, they show a picture of potentially some farm implement out in a field, and says he's the only one that could have been out there doing that. There was nothing to suggest that he was the only one that could have been out there doing that. We know Jaron was on the farm. We also know, based on their own witness testimony, Todd Nayrink, that he was at the office, left the office when a little before the kids did. He goes out, does whatever he's doing, and he goes and meets Todd at or the defendant at the spray barn. He says, I didn't go in the spray barn, but that's where Dale was. He didn't say he was out in the field planting or plowing or doing any of that. He was out at the spray barn. So again, we have that amount of time. in the spray barn. 5:07 to 6:06. Again, he's clearly in there for that hour of time. There's additional time that he's in there that is, 5-10 minutes here and there. Granted, that's not a lot of time together, but you don't have to cut off the end cap all at one time. You can cut off 5 minutes here, 5 minutes there. But he has more than ample time to get this done. The defense talks about how the defendant knew that Ivan and his brother were in the old shop working on the vehicle that day. He sure did. He didn't take the welder out of the old shop. He went to the new shop when he needed a welder. He went in there and he grabbed the angle grinder and the discs. And he didn't take the tank into the old shop to weld it there because number one, there's surveillance cameras in there. Number two, Ivan's in there. He also didn't take it into the new shop to weld it. Again, that's the other place that we've heard testimony the welding is done, the old shop or the new shop. He didn't take it into the new shop because, again, there are surveillance cameras in there. Where does he take it? He takes the tank and the welder to the one place on the farm that nobody welds, and there's no surveillance cameras. There's been an argument that the defendant takes no action to hide what he's doing on the farm that day. He is welding in the spray barn where you don't weld. Well, he could have been fixing this or he could have been doing that. Then why not weld where the welders are? He was absolutely hiding what he was welding when he took that to the spray barn. There was indication that he was criticized for looking over Zach Bach's shoulders when Zach was looking at the cameras. Again, the defendant is in and out of the office, seeing what's going on the surveillance. Would he want to know what's caught on camera? Absolutely. Is he looking for his wife? No. Was he looking for his wife when he tried to access the cameras at 8:48 and 8:49 that morning? No. What is caught on camera? Between 2:18 and 2:46, the sprayer moves from the front of the office and gets parked in the between the surveillance camera from the office and the spray barn. So if you'll remember, he leaves the property, he's back by 2:18, he parks in front of the office, he goes in, talks to the kids, looks over their shoulder some more, and goes and moves the sprayer and parks it in front of that camera. The defense indicated that there was no single trace that Dee Warner was killed in the property. Think about what the medical examiner said. Those injuries don't necessarily mean she was bleeding out. She suffered multiple blunt force injuries. And the wording of it sounds awful, but he did indicate that did not mean that she was bleeding out. In the days after Dee Warner was last seen alive, Kevin Greca walked through the property on the 26th and observed things, made no indication of what types of searching he did or how hard he searched. But I will acknowledge that there's no big piles of blood. Again, medical examiner says, no, not necessarily. Doesn't mean you would see blood. The medical examiner cannot determine the exact date of death or the time of death. That's correct. This is not TV, right? What did he say? The way that they work in the medical examiner's office is they work with law enforcement to determine the facts surrounding the case. When was the last time anybody saw this person alive? The last time anybody saw this person alive was Dale Warner at 6 a.m. when she was snoring away on the couch, or Amy Alexander, who saw her at 7:40 the night before when she picked up Lena for the night. No duct tape, no tarp is on surveillance. Doesn't mean he didn't get those items. You guys went through the house. Could they have been in the garage? Could they have been in the attic? Could they have been anywhere else where surveillance may not have picked them up? Absolutely. He was in the spray barn while her kids were in the office. Again, with a grinder where that office is located. Those kids stayed in the office the entire time looking at the cameras to see if they could find their mom. With the location of that office, you're not going to hear that grinder. The paint. Justin Schmidt testified that the welding fairly quickly after you weld that, you could paint it. But he indicated the only spot that he saw that had paint on it in that photograph was the strip right around the weld, which is consistent with the paint expert who said you have layers of paint and then you have one additional layer of paint that's just under that weld. And that's the only spot on that tank that had that additional layer of paint. Where's the paintbrush? Where's the anything that was used in the spray barn? The trash was taken out to the trash pile to be burned. Did you see that on the surveillance footage? You've got the tank on the far corner of the screen, and in the burn pit, you have a pile of trash from the spray barn. He continuously consented to searching all of his land again. Sure, come search. Not here, not now. You can search anywhere you want, but you can't search here. You have, yes, you have a right to say you don't want somebody to search. But when they come back later with a search warrant to search your property, and you come back onto the property and remove an item that is similar to the tank that her body is found in, again, a very unique tank, and you have come back to the property while the police are there searching. The dogs are 20 minutes out and you're 18 minutes, you're back and you're moving that tank and then you're gone again. Talked about the canine tracks again. What would that cadaver dog smell? Nothing. She's in the tank by the 25th at 6:39 p.m. So all the searches, all the canine tracks that didn't locate her, they were never going to locate her. The question was, where are the items that went missing from the home? The go bag, the purse, the phone, the wallet. Between Munger and Brooklyn, there's an awful lot of property. I don't have those phones, those go bags. I don't have anything. We were never able to recover any of those items. Again, your article search dog, the canine officer said, what do you say about finding those items? They're outside in the elements, maybe 24 hours. When was the first search that they did? of those properties. Not within 24 hours. Defense says, despite what Dreyer said on the stand, despite what said, Dreyer said his statements were fairly consistent, which again was taken out of context. Yes, some statements were fairly consistent, but if you continue to read the report, Detective Dreyer went into the inconsistent statements. Defense claims that her client offered assistance in the background. He's got a 9-year-old that he's trying to take care of. The 9-year-old that he consistently throughout interviews said that he had never home, never had anything to do with her. I've got to work. I got a farm. My brother's got her. My brother's girlfriend's got her. What about Greg Hardy and some of the things he did? You mean like offering a reward for the return of his sister? Putting together all the search parties that walked out and looked for her? This defendant didn't go out looking for her. The defense stated the defendant didn't really think suicide was a real possibility. That's one of the first things he brought up on 425 when Austin Hall gets there. She was talking about killing herself and taking off and leaving. And then the next day with Greca, what does he say? Yeah, my wife's depressed. 427, she's suicidal. She tried to kill herself once, 3 times throughout the course of our marriage. He is the one that brought that up first. He had to be prompted to talk about Mexico and Jamaica. Detective Dreyer explained why he asked that question because throughout the course of this entire investigation, while his wife has been gone, he said numerous times, I'm 100% she's in Mexico or Jamaica. And it's because she thought it was beautiful there. The cartel. She's living with the cartel. Again, does it make sense that Dee Warner's getting on a $10 boat ride? During his interviews, the defendant acted like he didn't know why Dee stopped going to counseling. I'm doing everything I can to fix this marriage. She stopped going. I don't know why. I don't know what happened. Very clearly, in one of the text messages that you guys have, she says, I'm not going to Craig anymore. I'm the one doing all the work. I'm not doing it. I'm not doing it. There was testimony by people that Dale would rub Dee's shoulders. And when they were fighting, she was clearly uncomfortable with that. The Vinx device, that's going to be the tracker that Brian Bush testified about, that Stephanie Vocal testified about, and the defendant himself gave numerous statements about. Danielle Vanden Heuvel, the expert, the phone data expert, testified that that app was actually purchased by Dale Warner's device, but not downloaded. So he did purchase and not download. Brian Bush, he when asked to describe his relationship with Dee, what'd he say? Depends on what the day was, Sometimes it was good, sometimes it was bad. His relationship with Dale was always like a father figure to him. There was a suggestion that the defendant didn't check OnStar when she was sneaking out because she didn't drive the Cadillac. Numerous statements he's given. She has never left here without a vehicle. And he wasn't allowing her to drive the Hummer because it took up too much gas, and the only place that she could drive it was out to the field to bring him food. Again, never brought that up to the police as a concern. My wife's been sneaking out. I don't know where she's been going. Stacy Brody testified twice before coming here, and she never once described the bruise as looking like a handprint. However, when she was shown her police report that her statement to the police that she made prior to ever testifying in any court, she clearly described that bruising as a handprint. The 23rd, when Todd says he's in the office and he gets into it with Dee and sees her in sweatpants, Stephanie was there too. She testified about that. What else did she say? I have never seen Dee Warner outside the house in pajamas or anything less than always dressed up. She always had to have the best on. Defendant was checking her phone location that morning. The argument is if he knew that she was dead, why would he keep checking her phone location? He wouldn't keep doing this. No, you would, right? For the same reason that you would duct tape her mouth and nose, you don't want her to ever breathe again. I need to know that that phone is not going to ever ping. I need to know that nobody's going to find that device. They talked about people roaming all over the property, yet we've heard Ivan Boyd and his brother were in the old shop. The entire family was in the office, and there were 2 employees that came into the old shop to clock in and clock out. They brought up Maddie's testimony that Dee would sometimes walk to the office. She had no socks and shoes on. Again, you've been on the property. You've heard the description of Dee Warner. She has never left her house in her pajamas and wouldn't be walking down to the shop without her socks or shoes on. April 27th, it was brought up. Well, why wouldn't he just move the tank himself when law enforcement was there if they were going to come back? He didn't have to. He asked Jason Gravel to do it. Go back there and move that tank for me and put it in the spray barn. Again, what does Jason Gravel do? He moves the wrong tank. He did testify that it wasn't uncommon for him to move tanks, but what else did he say? That was the only time that the defendant has ever called me and asked me to put a tank inside the spray barn. The only time. '27th, Parker Hardy goes in the barn in the spray barn at 7 p.m. This is before tank 34 is brought in. Again, this is when the old rusty tank 8 is in there. Why would he notice the weld on tank 8? Tank 8 did not contain Dee Warner's body. Tank 34 did. And at that time, tank 34 was still over at the burn pit. Parker was the only person that saw the JCB tracks leading up to the house. Except for Dale confirms that he pulled the JCB directly up to the house and came back inside the house through numerous interviews. Again, Dr. Cho, the date of death, he testified he was not concerned at all that the date of death would be 4/25/2021. I said her body was kind of in pretty well preserved, doctors. Are you concerned about that? What'd he say? No, there's no oxygen getting in that tank. the defense brought up that Dr. Cho said they could have been sweatpants. Again, Raquel looked at those photographs. She identified those as her mother's pajamas. Justin testified that cutting that end of that tank off would have been faster with a plasma cutter. Sure, of course. Why would you use that? Why wouldn't you use the plasma cutter? Well, what else did he say? If you want to weld it back together, it makes sense to use an abrasive cutting wheel. You don't use a plasma cutter if you plan to put that item back together. They can't match the chain or hook. Dee Warner was last seen on 4/24/2021, again by Amy Alexander, or 4/25/2021 by the defendant. And her body was not discovered until August 2024. Those items are gone. They went back and executed a search warrant after they found her body. The defendant says chemicals can cause burns. Sure. We had Ryan Rankin here talking about chemical burns. That burn was consistent with a welding burn, not a chemical burn. The fingerprints. The defense says the stickers were peeled off the tank when the paint analyst went to get paint scrapings. Who cares? The person who the fingerprint analyst was the first person to do anything with that tank. She came to Northville, dusted the tank, pulled the stickers off. So the stickers are going to be off before the paint analyst came and did her portion. So of course those stickers are going to be off. Look at the exhibit with the Google searches on it. It'll tell you the search term on there. The search term is chemical cremation. The items that were clicked were, why is it illegal? Chemical cremation, why is it illegal? There's no suggestion that he typed in why is it illegal? Go to that particular document and look what's in there. Chemical cremation. Where does he go? You know, when you type in something in Google and then you go down and pick the one you want and you click on that and read it, that's what that document is. Fingernail clippings were not sent to the lab for DNA. How many times did you hear that nothing inside that tank was suitable for DNA testing because of the chemicals? Detective Dreyer worked closely with the lab to try to get some of that stuff processed, and they could not be processed because the items were not suitable for testing. We didn't bring an expert in to tell you that the writing on the tag is the defendant's. I mean, look at the writing yourself. You've got plenty of documents. You're going to be able to come to your own conclusion on that. There was a suggestion that Terry and Todd weren't spoken to, that none of these people were looked at or talked to. That's simply not true. And finally, the defense indicates that if this crime was premeditated, he would have had all those items already. They would have been ready for him to go, ready for him to cut that off, ready for him to do the welding back. Again, premeditation, deliberation, they do not take that long. I don't have to think about it, go plan it, go pull my welder in and then go kill her and then weld her up, right? We talked about the yellow light. When you see a yellow light, or you think, what do you think? You've heard about her injuries. 1, 2, 3, 4. How many chances did he get to think about it? Then she was strangled to death. 5. How many chances did he get to think about what he was doing? And then not only that, let's assume 3 or 4 knocks her out, 5, she's unconscious. What do? Call for help, right? I screwed up. I hurt my wife. Come help. This defendant duct taped her mouth and her nose so that she could not breathe again. Those were all conscious decisions. 1, 2, 3, 4. Every one of them. You will have the surveillance footage. You will have every piece of evidence that's been presented. Anything you want to look into further, please look at it. Ask for it. We want you to look at it. We want you to return a verdict of guilty, first-degree murder, and tampering with evidence.
All right, ladies and gentlemen of the jury, we do have a procedural step that we need to take care of outside of your presence. So at this point, I'm going to ask you to return to the jury room. We will take a short break. We'll come back. I'll give you the final instruction. Yes. All right, we do need to make a record of the jury instructions. It's my understanding at this point that both sides have had an opportunity to review the instructions and are in agreement with them in their current form. Is that correct?
That's correct, Your Honor.
That's correct, Your Honor.
Okay, anything at all that either side would like to place on the record regarding the instructions?
No.
Okay. At this point, so that there is a record of them, I am going to read the instruction numbers into the record. And so the preliminary instructions were 1.1, 1.2, 1.3, 2.17, 1.4, 1.5, 1.6, 1.8, 1.9, 2.1, 2.2, 2.3, 2.4, 16.24, 16.01, 16.05, 16.21, 37.11, 3.10, 4.09, 4.16, 2.5, 2.6, 2.7, 2.8, 2.9, 2.10, 2.11, 2.12, 2.13, 2.14, 2.15, 2.16, 2.19, 2.20, 2.25, 2.26, 2.27, and 2.28. 2.17 was the publicity instruction. And the final instructions will be 3.1, 3.2, 3.5, 3.14, 3.15, 3.16, 4.3, 3.6, 4.05, 5.2, 5.3, 5.10, 5.11, 5.11A, 3.03, 4.01, 3.20, 16.01, 16.05, 16.21, 37.11, 3.10, 4.09, 4.16, 3.13, and 3.11. All right, at this point, why don't we take 10 minutes for people to get up and stretch for a moment, and we'll come back then and resume with final instructions. Exciting.
Your Honor, may we approach, please?
You may.
Thank you.
We are.
Mhm.
So. All right, are we ready to bring the jury back in?
Yes, Your Honor.
Yes, Your Honor.
You may be seated. Members of the jury, the evidence and arguments in this case are finished, and I will now instruct you on the law. That is, I will explain the law that applies to this case. Remember that you have taken an oath to return a true and just verdict based only on the evidence and my instructions on the law. You must not let sympathy, bias, or prejudice influence your decision. You must avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. As jurors, you must decide what the facts of the case are. This is your job and no one else's. You must think about all of the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It is my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. At various times, I have already given you some instructions about the law. You must take my instructions together as the law that you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way, to decide the case. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Each crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but a doubt that is based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. When you discuss the case and decide on your verdict, you may only consider the evidence that has been properly admitted in this case. Therefore, it is important for you to understand what is evidence and what is not evidence. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I told you to consider as evidence. Many things are not evidence, and you must be careful not to consider them as such. I will now describe some things that are not evidence. The fact that the defendant is charged with a crime and is on trial is not evidence. Likewise, the fact that he is charged with more than one crime is not evidence. The lawyer's statements and arguments are not evidence. They are only meant to help you understand the evidence and each side's legal theories. You should only accept things that the lawyers say that are supported by the evidence or by your own common sense and general knowledge. The lawyer's questions to the witnesses, your questions to the witnesses, and my questions to the witnesses are also not evidence. You should consider these questions only as they give meaning to the witnesses' answers. My comments, rulings, questions, and instructions are also not evidence. It is my duty to see that the trial is conducted according to the law and to tell you the law that applies to the case. However, when I make a comment or give an instruction, I am not trying to influence your vote or express a personal opinion about the case. If you believe that I have an opinion about how you should decide the case, you must pay no attention to that opinion. You are the only judges of the facts, and you should decide this case from the evidence. At times during the trial, I've excluded evidence that was offered or stricken testimony that was heard. Do not consider those things in deciding the case. Make your decisions only on the evidence that I let in and nothing else. Questions and comments made by law enforcement during the defendant's interrogation and interviews are also not evidence. You should consider those questions and comments only as they give meaning to the defendant's answers. Your decision should be based on all the evidence, regardless of which party produced it. You should use your own common sense and general knowledge in weighing and judging the evidence, but you should not use any personal knowledge you have about a place, person, or event. To repeat once more, you must decide the case based only on the evidence admitted during this trial. If you want to communicate with me while you are in the jury room, please have your foreperson write a note and give it to the bailiff. It is not proper for you to talk directly with the judge, lawyers, court officers, or other people involved in the case. As you discuss the case, you must not let anyone, even me, know how your voting stands. Therefore, until you return with a unanimous verdict, do not reveal this to anyone outside the jury room. When you go to the jury room to deliberate, you may take your notes and the full instructions. If you want to look at any or all of the reference documents or exhibits that have been admitted, just ask for them. When you go to the jury room, you will be given a copy of the instructions you have just heard. As you discuss the case, you should think about all my instructions together as the law that you are to follow. Facts can be proved by direct evidence from a witness or an exhibit. Direct evidence is evidence about what we actually see or hear. For example, if you look outside and see rain falling, that is direct evidence that it is raining. Facts can also be proved by indirect or circumstantial evidence. Circumstantial evidence is evidence that normally or reasonably leads to other facts. So, for example, if you see a person come in from outside wearing a raincoat covered with small drops of water, that would be circumstantial evidence that it is raining. You may consider circumstantial evidence. Circumstantial evidence by itself, or a combination of circumstantial evidence and direct evidence, can be used to prove the elements of a crime. In other words, you should consider all the evidence that you believe. As I said before, it is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any witness's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you may have and not be influenced by a witness's disability, gender, gender identity, race, religion, ethnicity, sexual orientation, age, national origin, or socioeconomic status. Again, take the time you need to test what might be automatic or instinctive judgments and reflect carefully on the evidence. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Did the witness seem to have a good memory? How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Or did the witness seem to evade the questions or argue with the lawyers? Does the witness's age, maturity level affect how you judge his or her testimony? Does the witness have any bias, prejudice, or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testified? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think that someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, but simply be wrong about what they thought they saw or remembered. It is also a good idea to think about which testimony agrees best with the other evidence in this case. However, you may conclude that a witness deliberately lied about something that is important to how you decide this case. If so, you may choose not to accept anything that witness said. On the other hand, if you think that the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. You have heard evidence that before the trial, witnesses made statements that may be inconsistent with their testimony here in court. You may consider an inconsistent statement before the trial only to help you decide how believable you think the witness's testimony was when testifying in court. If the earlier statement was made under oath, then you may also consider the earlier statement as evidence of the truth of whatever the witness said in the earlier statements when determining the facts of this case. You should not decide this case based on which side presented more witnesses. Instead, you should think about each witness and each piece of evidence and whether you believe them. Then you must decide whether the testimony and evidence you believe proves beyond a reasonable doubt that the defendant is guilty. You have heard that a lawyer or lawyer's representative talked to one or more of the witnesses. There is nothing wrong with this. A lawyer or lawyer's representative may talk to a witness to find out what the witness knows about the case and what the witness's testimony will be. You have heard testimony from a witness, Dr. Patrick Cho, who has given you his opinion as an expert in the field of forensic pathology. Amanda Isett, who has given you her opinion as an expert in the field of fingerprint analysis. Michelle Ponchke, who has given you her opinion as an expert in the field of paint analysis. Justin Schmidt, who has given you his opinion as an expert in the field of welding fabrication, inspection, and certification. And Jordan Graves, who has given you his opinion as an expert in the field of digital media forensics. Experts are allowed to give opinions in court about matters that they are experts on. However, you do not have to believe an expert's opinion. Instead, you should decide whether you believe it and how important you think it is. When you decide whether you believe an expert's opinion, think carefully about the reasons and facts they give for their opinions and whether or not those facts are true. You should also think about the expert's qualifications and whether their opinion makes sense when you think about all of the other evidence in this case. You have heard testimony from witnesses who are police officers. The testimony is to be judged by the same standards you use to evaluate the testimony of any other witness. You have heard evidence that the defendant engaged in stalking behavior and domestic violence. He is not on trial for those acts. Before you may consider this evidence against the defendant, you must first find that the defendant actually committed those acts. If you find that the defendant did commit the acts, you may consider them in deciding whether the defendant committed the offenses for which he is now on trial. You must not convict the defendant in this case solely because you think he is guilty of other bad conduct. The evidence must convince you beyond a reason the defendant committed the offenses for which he is now on trial, or you must find him not guilty. Every defendant has an absolute right not to testify. When you decide the case, you must not consider the fact that he did not testify. It must not affect your verdict in any way. The prosecution has introduced evidence of a statement that it claims the defendant made. Before you may consider such an out-of-court statement against the defendant, you must first find that the defendant actually made the statement as given to you. If you find that the defendant did make the statement, you may give the statement whatever weight you think it deserves. In deciding this case, you should think about how and when the statement was made and about all the other evidence in the case. You may consider the statement in deciding the facts of the case. The defendant is charged with 2 counts, that is, with the crimes of open murder homicide and tampering with evidence. These are separate crimes, and the prosecutor is charging that the defendant committed both of them. You must consider each crime separately in light of all of the evidence in the case. You may find the defendant guilty of all or any one of these crimes, or not guilty. The defendant is charged with the crime of first-degree premeditated murder. To prove this charge, the prosecutor must prove the following elements beyond reasonable doubt. First, that the defendant caused the death of Dee Warner, that is, that Dee Warner died as a result of blunt force trauma and/or strangulation. Second, that the defendant intended to kill Dee Warner. Third, that this intent to kill was premeditated, that is, thought out beforehand. Fourth, that the killing was deliberate, which means that the defendant considered the pros and cons of the killing and thought about and chose his actions before he did it. There must have been real and substantial reflection for long enough to give a reasonable person a chance to think twice about the intent to kill. The law does not say how much time is needed. It is for you to decide if enough time passed under the circumstances of this case. The killing cannot be the result of a sudden impulse without thought or reflection. You may also consider the lesser charge of second-degree murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant caused the death of Dee Warner, that is, that Dee Warner died as a result of blunt force trauma and/or strangulation. Second, that the defendant had one of these 3 states of mind. He intended to kill, or he intended to do great bodily harm to Dee Warner, or he knowingly created a very high risk of death or great bodily harm, knowing that the death that death or such harm would be the likely result of his actions. You must think about all the evidence in deciding what the defendant's state of mind was at the time of the alleged killing. The defendant's state of mind may be inferred from the kind of weapon he used, type of wounds inflicted, the acts or words of the defendant, and any other circumstances surrounding the alleged killing. Premeditation and deliberation may be inferred from any actions of the defendant which show planning or from any other circumstances surrounding the killing. The prosecutor need not prove a motive for the killing, but you may consider evidence of a motive in deciding if there was premeditation and deliberation. Motive by itself does not prove premeditation and deliberation. The defendant is charged in count 2 with tampering with evidence. The defendant is charged with intentionally removing, altering, concealing, destroying, or tampering with evidence to be offered in an official proceeding. To prove this charge, the prosecutor must prove each of the following elements beyond reasonable doubt. First, that there was some evidence to be offered in a present or future official proceeding. An official proceeding is a hearing held before a legislative, judicial, administrative, or other governmental agency, or a hearing before an official authorized to hear evidence under oath, including a referee, a prosecuting attorney, a hearing examiner, a commissioner, a notary, or another person taking testimony in a proceeding. Second, that the defendant removed, altered, concealed, or otherwise tampered with that evidence. Third, that the defendant removed, altered, concealed, destroyed, or otherwise tampered with that evidence. He did so on purpose and not by accident. Fourth, that the evidence that the defendant removed, altered, concealed, destroyed, or otherwise tampered with was used or intended to be used in a criminal case where open murder homicide was charged. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about April 25, 2021 within Lenawee County. You may consider whether the defendant had a reason to commit the alleged crime, but a reason by itself is not enough to find a person guilty of a crime. The prosecutor does not have to prove that the defendant had a reason to commit the alleged crime. She only has to show that the defendant actually committed the crime and that he meant to do so. The defendant's intent may be proved by what he said, what he did, or by any other facts and circumstances in evidence. Possible penalty should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by the law. When you go to the jury room, you will be provided a written copy of these final jury instructions. You should first choose a foreperson. The foreperson should see to it that your discussions are carried out in a businesslike way and that everyone has a fair chance to be heard. During your deliberations, please turn off your cell phones or other communications equipment until we recess. A verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agrees on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. It is your duty as jurors to talk to each other and make every reasonable effort to reach agreement. Express your opinions and your reasons for them, but keep an open mind as you listen to your fellow jurors. Rethink your opinions and do not hesitate to change your mind if you decide that you were wrong. Try your best to work out your differences. However, although you should try to reach agreement, none of you should give up your honest opinion about the case just because other jurors disagree with you or just for the sake of reaching a verdict. In the end, your vote must be your own, and you must vote honestly and in good conscience. If you have any questions about the jury instructions before you begin deliberations or questions about the instructions that arise during your deliberations, you may submit them in writing in a sealed envelope to the bailiff. I have prepared a verdict form that lists the possible verdicts. So at this time, ladies and gentlemen, we will ask you to return to the jury room and begin your deliberations. As I said earlier, oh, sorry, yeah. I apologize. So Ms. Escott, we do need to draw our jurors who are the alternates that will be excused at this point.
I will call 4 jurors who will be excused at this time. I will refer to you by seat number.
And as you do that, I'm going to ask that if you are excused, that you come out through the door that you've been coming in and out of, and that way.
Juror in seat number 11 will be excused by stipulation of the parties. Seat number 5. Seat number 14. Seat number 2.
All right, we will give them a moment to collect their things and to collect their notebooks. In the meantime, Madam Clerk, would you please swear the office? Oh, I'm sorry, that's gonna, I apologize. So we'll need Deputy Esposito to come back.
All right.
Oh, now, Madam Clerk, would you please swear the officer?
Raise your right hand. Do you solemnly swear that you will, to the best of your ability, keep the persons sworn as jurors in this trial from separating from each other, that you will not permit any communication to be made to them or to any of them, orally or otherwise, that you will not communicate with them or with any of them, orally or otherwise, except by the order of this court, or to ask them if they have agreed upon a verdict, until they shall be discharged, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they've agreed upon.
At this point, ladies and gentlemen, we will ask you to return to the jury room and begin your deliberations. All right, is there anything that either side would like to address on the record at this point?
No.
We would like a sidebar, like, okay, yeah, you can approach. All right, so, process wise, what we will do is allow the jury to, deliberate today until sometime between 5:30 and 6 o'clock, which is normally what I do when we, get to this point in the day. There are some issues that need to be resolved in the event that the jurors ask for certain exhibits, and it's my understanding the attorneys are gonna work on resolving that now in terms of how to put those in a format that the jurors would be able to work with.
That's correct, Your Honor.
That's correct. Thank you.
All right, we will be in recess then.
Sorry.